Hands on the wheel where I can see them, and don't get creative with me tonight." The flashlight came up before the words finished, riding the window glass and then her face, holding there long past the point of need. Delilah Ashcroft put both palms flat on the wheel at 10 and 2 and kept them there. Beside her, her nephew's shoulders had gone rigid against the seat back, 17 years old and already understanding that the safest thing his body could do was nothing at all. The cruiser's lights washed the corn stubble on both shoulders in alternating red and blue. 2 lanes of county highway, no street lamp for a mile in either direction, the kind of dark that made a traffic stop feel less like a procedure and more like a room with the door shut. License, registration, proof of insurance, slow. She moved slowly. She narrated as she moved, not for the officer, but for the boy. "I'm opening the glove box now. Caleb, I want you to keep your hands on your knees." The documents came out clean and squared, the way she kept everything, and she passed them through the gap in the window without letting her fingers cross the frame. The officer read the name on the license twice. Then he looked past her at the boy, and something in his mouth settled, the way a man's face settles when he has decided what a situation is going to be. "Reason for the stop," she said. "Not a question, just a placeholder in a record she was already beginning to build." Plate lights out. She let 3 seconds go by. Then, without turning her head, she spoke to her nephew in a voice pitched to carry exactly as far as the driver's door and no farther. "Caleb, read that sign behind us out loud." He hesitated. Then, quietly, "County Route 9, speed limit 55. Delphi County maintains." "Good. Now the number on the front of that cruiser." 412. "Say it again." 412. "Remember it," she said. "The whole night? Every number." The officer's flashlight came back to her face and stayed. Somewhere behind them a truck passed on the far lane and did not slow, its taillights shrinking into the black, and the world went back to being 2 people in a car and 1 man outside it with a radio. He stepped away without returning her license. The door locks clicked twice, and then there was no sound at all. She had come back to Quarry Hollow, Ohio, to bury her aunt, and for 4 days that had been the entire purpose of her existence. Martha Ashcroft had raised Delilah for 6 years after her mother's second hospitalization and had never once described it as a sacrifice. And when she died at 88 in a rented hospital bed in the front room of a house she had owned outright since 1971, she left behind a filing cabinet, a coin jar, and a nephew's son, with no other adult willing to sign anything. The memorial was held in the Quarry Hollow Community Hall, a long, low building with a linoleum floor and a serving window into a kitchen, because the funeral home charged for chapel time by the half hour, and Delilah had done the arithmetic in the parking lot and decided the arithmetic was insulting. She rented the hall for $40. She bought the flowers herself from a stand outside the grocery on Route 9. She set out 60 folding chairs, and 41 people came, which she noted without bitterness, because she had learned a long time ago that counting was not the same as judging. The funeral director had called her twice before she arrived. The second call had a texture to it. "I just want to confirm the payment arrangement," he said. "Sometimes with out-of-town family, there's a question of who's actually responsible." "There isn't a question." "Well, we do like to have the responsible party." "You have her," Delilah said. "You've had her since Tuesday. The wire cleared Wednesday morning at 10:45 a.m. I have the confirmation number if you'd like it." He did not want the confirmation number. He wanted, she thought afterward in the car, something else, something he could not have named himself, and she had declined to provide it. She wrote the time of the call in the margin of the receipt anyway. She dated it, she initialed it. She had been doing that for 29 years, on gas receipts and boarding passes and pharmacy printouts, a habit so deeply grooved that she no longer registered it as a habit. Caleb had noticed it once, when he was 11, and asked her why. "Because the paper forgets," she had told him. "And I don't like to argue with people about what happened." At the hall, she wore a gray cardigan over a black dress and flat shoes, and she did not sit in the front row because she was busy. She refilled the coffee. She found a second extension cord. She got a folding chair with a bent leg out of circulation before somebody's grandmother put her weight on it. When a woman she did not recognize asked whether there'd be a program printed, Delilah said no and handed her a coffee and moved on, and the woman looked mildly affronted, and that was fine. Heather Lindgren arrived at 2:30 with a covered dish, and the particular smile of a person who has decided to be gracious in advance. She was chair of the Quarry Hollow Village Council, a position she had held for 11 years, and she introduced herself that way, chair of the council, as though it were a rank. She set the dish on the table without looking at it. She looked at the room. "I did want to come by," she said. Martha was a fixture, absolutely a fixture. She kept that lot mowed for decades. She did. "So you're the niece." A tilt of the head. "And how long are we keeping you?" Not "how long are you staying?" "How long are we keeping you?" As though there were an inventory somewhere, and Delilah was a temporary line item on it. "Through the end of the month," Delilah said. "There's an estate to close." Of course, of course. Lindgren's eyes moved to Caleb, who was stacking chairs by the door in a suit that had fit him better a year ago. "And that's Martha's grandnephew? He's living out there now?" "He is." "Alone?" "He's 17. He's with me." The syllable did a great deal of work. "It's just, the neighbors do notice. There's been some coming and going at that address, and I'd hate for anyone to get the wrong idea about a young man they haven't met." Delilah looked at her for a full second before answering, which was longer than most people were comfortable being looked at. "Then they should meet him," she said. "He's 12 feet from you." Lindgren laughed the way people laugh when they have decided to file something away instead of continuing it, and moved on to the coffee, and by 4 o'clock she had spoken to 11 separate people, and by 6 o'clock a private group on a neighborhood app had a new post in it that Delilah would not see for another 9 days. If you've ever been sized up by a stranger who already decided what you were, stay with this one. Hit that like button. It genuinely helps this story reach the people who need it. That night, Caleb sat on the porch steps with his phone and told her the engineering scholarship had gone to the next stage. It was a real thing, a State Industrial Foundation award, 4 years plus a summer placement at a tooling plant outside Dayton, and he had made the final 90 out of 1,100 applicants. The last step was a standard background review, his and the household's. He read her the email in a voice he was trying to keep flat and failing. "It says results in 6 to 8 weeks. Then we wait 6 to 8 weeks. There's nothing on me. I know there isn't." He turned the phone over in his hands. "There's nothing on you either, right?" She let the porch light buzz for a moment. Insects hit the glass and fell and hit it again. "There's nothing on me," she said. He nodded, satisfied, and went inside, and she sat out there another 40 minutes with the folder of estate documents on her knees, arranging them by date, writing times in the margins, listening to a county road with almost nothing on it. 9 days later, they drove into Delphi for the probate clerk's office, because the clerk had rejected a filing twice over a signature block, and the office closed at 4, and the drive back put them on County Route 9 at a little after 9 at night. The cruiser came out of a gravel turnaround with no headlights and picked them up within a quarter-mile. She signaled. She pulled onto the shoulder, well past the drop-off. She turned on the dome light, put the window down all the way, shut off the engine, and set the keys on the dash, where they could be seen. All of it before the officer's door had opened. His nameplate read Whitaker. He was maybe 34, thick through the chest, and he had the particular energy of a man who had been sitting in a dark turnaround for 2 hours with nothing to do. The plate light was the reason he gave. It was a real reason. Ohio Revised Code Section 4513.05 requires the rear registration plate to be illuminated so as to be legible from 50 feet. Delilah had replaced that bulb 11 days earlier at a parts store off the state route, and she had the receipt in the glove box, dated and initialed, and she said nothing about it. She said nothing about it because she had learned that the correction is never the point. The correction is a doorway, and men like this are standing in it. He took her license and registration back to the cruiser. 6 minutes passed, then 8, then 11. At 11 minutes, she said, quietly, "Caleb, what time is it?" He checked. 9:16. Say it out loud once more. 9:16 p.m. Thank you. Whitaker came back without the documents. He asked her to step out of the vehicle. She asked whether she was free to leave. He said she was being detained. She asked the basis. He said he'd let her know. She got out. She kept her hands visible. She did not lean on the car, because leaning on the car gives a man something to describe later. Where you two coming from? Delphi, probate clerk's office. Probate. My aunt died. Uh-huh. He looked past her at the boy in the passenger seat, and his mouth did that settling thing again. He seems nervous. He's 17, and it's dark. Nervous people usually got a reason. A second cruiser arrived at 9:29. A third unit, a K-9 handler out of the county, arrived at 9:33. That was 26 minutes after the initial stop, and by then the reason for the stop, a bulb, had been complete and resolved for nearly 20 of them. There is a Supreme Court decision on exactly this, Rodriguez versus United States, decided in 2015. A traffic stop may last no longer than necessary to address the violation that justified it. Absent reasonable suspicion, extending it to conduct a dog sniff violates the Fourth Amendment. Delilah knew the case the way a plumber knows water pressure. She did not recite it. She stood on the gravel, with her hands loose at her sides, and let the minutes accumulate, because the minutes were the only thing on that road that belonged to her. The dog alerted at the passenger side rear door, or the handler said it alerted. On a road with no fixed camera, at 9:38 at night, those are the same sentence. Whitaker searched the vehicle for 19 minutes. He pulled the floor mats. He ran his hand under the passenger seat rail twice, and the second time he came out with a small twist of clear plastic containing an off-white powder, and he held it up between two fingers at shoulder height, turning slightly so the other officers could see it, and he said, in a voice pitched for an audience of 3, Well now, look at what a probate lawyer keeps under the seat. Caleb made a sound. Not a word. Delilah heard it, and it went through her like a wire. Don't, she said. Just that. Don't say anything, baby. Not one word. They cuffed her on the trunk lid. The metal was still warm from the engine. She heard the ratchet close and then close again. An extra click passed snug, and she did not react to that either, because reaction is a currency, and she had decided hours ago, years ago, honestly, not to spend it in front of people like this. Over her shoulder she could see the boy standing on the shoulder of the road in a hooded sweatshirt with a second officer's hand on his upper arm, and she made herself look at the middle distance instead, at the corn, at the black, because if she looked at him she was going to become a different woman than the one this required. What she said, as they turned her toward the cruiser, was not a threat and not a protest. I'd like the time noted, 9:51 p.m., and I'd like the case number when it exists. Whitaker laughed. You'll get a lot of paper, ma'am. Don't you worry. The door shut. The locks went twice. Then nothing. Delphi County Jail booked her at 11:22 p.m. on a charge of possession of a controlled substance under Ohio Revised Code, Section 2925.11, a felony of the 5th degree, at the weight alleged. She gave her name, her date of birth, her address of record. She answered the booking questions, which do not require a warning, because booking questions are administrative, and the warning attaches to custodial interrogation, and no one interrogated her that night. No one asked her a single substantive question about the powder. That was the first thing she filed away, and it was, in its way, the loudest. They took her cardigan, her shoes, her watch, and the contents of her pockets, which were inventoried on a property sheet she was asked to sign. She read the sheet before signing it. She read it twice. Then she signed it and asked for a copy, and the intake deputy said copies came later, and she said, I understand. I'm noting that I requested one at 11:41 p.m., and the deputy stared at her and wrote nothing. They put her in a holding cell with a concrete bench and a drain in the floor and a light that did not go off. Sometime after 2 in the morning, a woman 2 cells down began crying and stopped and began again, and Delilah sat with her back against the wall and her forearms on her knees and did the only useful thing available, which was to build the night backward in her head, minute by minute, and set it in order, and hold it there. 9:04, the lights. 9:06, the window. 9:16, Caleb's watch. 9:29, second unit. 9:33, dog. 9:38, alert. 9:51, cuffs. Caleb was released to a neighbor at 1 in the morning. He had not been charged with anything. He had also not been told where his aunt was, because nobody in that building considered it their job to tell him, and he sat on the curb outside the sheriff's substation for 2 hours, calling a phone that was in a manila envelope 40 yards away. They arraigned her Monday morning by video. Bond was set at $10,000, 10% to the clerk. She posted it herself with a card and was out by 2:30 in the afternoon, and the first thing she did was buy her nephew a hamburger and watch him eat it, and the second thing she did was request the incident report. That was where she met Sergeant Otis Pruitt. Pruitt ran the evidence room and the records window at the Quarry Hollow Department, both because it was a 9-officer agency in a village of 2,200, and he was the kind of man who had made his smallness into a discipline. He was thin and pressed, and he loved a form the way other men love a sports team. Public records request, he said, sliding a page under the glass. Fill it out completely. Incomplete requests get returned. I'm the defendant. I'm entitled to the report in discovery. Then you'll get it in discovery, through your attorney, to the prosecutor's office. A small, satisfied adjustment of his cuff. This window is public records, different track. How long on this track? Reasonable time, which is. Reasonable, Pruitt said, is what the statute says. It doesn't put a number on it, ma'am, and I'd be misleading you if I gave you one. That was technically correct, which was the worst kind of correct, and she recognized immediately that he knew it was technically correct, and that this was the pleasure of it. He was not lying to her. He was going to spend the next several months not lying to her, with tremendous precision. She filled out the form completely. She dated it. She photographed it before she surrendered it, standing right there at the window, and Pruitt watched her do it and said nothing, and something behind his eyes went from bored to interested, and she thought, there it is. He'll remember me now. She asked one more question on her way out. Is there body-worn camera on that department? On the officers, yes. All units? Pruitt's pause was 1 beat long. All units are equipped. Equipped. Not recording, not retained. Equipped. She wrote that word down in the parking lot with the time beside it. 3:18 p.m. The social layer arrived faster than the legal one, the way it always does. By Wednesday, the neighborhood app had 406 comments on a post that did not name her and did not need to. Drug arrest out on Route 9. 2 people in the vehicle, 1 juvenile. Right off our stretch. Somebody added that the residence in question was the old Ashcroft place. Somebody added that it had been sitting empty and now wasn't. Somebody added that they'd seen unfamiliar cars. Heather Lindgren commented twice, both times to urge everyone to please not speculate, in posts that speculated, and both of her comments got more reactions than anything else on the thread. The rental agent for the storage unit where Martha's furniture sat called to say there'd been a policy update and the unit needed a new cosigner. The neighbor who had picked Caleb up at 1 in the morning stopped answering. And on the 11th day, the Scholarship Foundation sent an email with a subject line that read, "Your application, status change. We have placed your candidacy on administrative hold pending clarification of a household background item. No decision has been made. Please respond within 30 days with any documentation you wish considered." Caleb read it standing in Martha's kitchen with the refrigerator running behind him, and then he set the phone face down on the counter with great care, like it was hot, and he did not look at her. "It's not you," she said. "It says household. It says pending clarification. Those are 2 different sentences, and only one of them is about you. Aunt Dee, look at me." She waited until he did. "In 30 days that hold gets answered. I need you to do 3 things and only 3. You go to school, you keep your grades, and you do not post one single word about any of this, anywhere, to anyone, ever. People are saying, I know what they're saying. They're saying it about you." "Then let them say it," Delilah said. "A person who is talking is not a person who is finished. Every hour they spend running their mouth is an hour they are handing me." He didn't understand that yet. He would. That night she sat at Martha's kitchen table with a legal pad and built the thing she had been building in the holding cell, only on paper this time, and in permanent ink. Gas receipt from the station on the state route, Time stamped 8:41 p.m. Probate clerk stamped filing 4:02 p.m. Text message from Caleb to a classmate at 7:55. The parts store receipt for the plate bulb, dated 11 days before the stop, with her own initials in the corner and the time written in her own hand. She built a timeline the way you build a wall, one course at a time. And she left gaps where she knew a document had to exist and did not yet belong to her. There were 4 gaps: dispatch log, body-worn camera, evidence submission sheet, lab report. She wrote each one on its own line, and beside each, she wrote the same 3 letters, NYT, not yet there. If a story about patience as a weapon is your kind of thing, subscribe. The second half of this one is why. The escalation went where escalations go, down. Fletcher Rand was the youngest officer on the Quarry Hollow Department, and the eagerest, and he had a habit that Delilah clocked the first time she saw him, which was that he checked other people's faces before he did things. He did not have the instinct. He had the audience. He turned up in her rear view, twice in a week, on a road that had 9 houses on it. He idled outside the community hall while she loaded chairs into a borrowed pickup. He ran her plate on the 3rd occasion, and she knew, because a plate query in that county pings a records terminal, and Otis Pruitt sat at that terminal, and Otis Pruitt had opinions about people who photographed forms. None of it was actionable. That was the design. The prosecutor's office presented the case to a Delphi County grand jury 5 weeks after the stop, and the grand jury did what grand juries do in roughly 99 cases out of 100, which is return an indictment. There is no defense at a grand jury. There is no cross-examination. The prosecutor speaks, and the officer speaks, and the room votes on probable cause, which is the lowest evidentiary bar in American criminal procedure, and Delilah Ashcroft was indicted on 1 count of possession under Section 2925.11 on a Thursday morning without ever being in the building. She learned about it from a voicemail. Her assigned counsel was Hazel Quimby, 31, 4 years out of law school, carrying a caseload of 142 open files in a county public defender office with 3 attorneys and 1 investigator who worked Tuesdays and Thursdays. Quimby was not lazy, and she was not stupid. She was drowning. They met for 22 minutes in a conference room with a broken chair. "Okay," Quimby said, paging. "So, 5th-degree felony. You're a first-time offender, no record whatsoever, which is genuinely unusual and genuinely helpful. The prosecutor's initial offer is a plea to attempted possession, 1st-degree misdemeanor, community control, no jail. Honestly, for this county, that's not a bad number." "I'm not taking a plea." Quimby looked up. Something in her face was tired in a way that had nothing to do with the hour. "Miss Ashcroft, I have to give you the real math, and the real math is this. If we go to trial, you are a woman in a car with a substance the state says came out from under your own seat, and there are 3 officers who will testify consistently because they will have read each other's reports before they wrote their own. Juries in this county convict. They convict a lot, and the exposure on a 5th-degree felony is up to 12 months. I understand the exposure. Do you understand the pattern? Because I've had 4 of these this year. It's always a corridor stop, always at night, and I have never once gotten a suppression motion granted in front of Judge Hollingsworth. What's your suppression theory?" Quimby blinked. Defendants did not usually ask that. Prolonged detention, she said. Rodriguez. 26 minutes for a plate bulb. Dog arrives after the purpose of the stop is complete. It's the right argument. It's also the argument I made in March and lost. Have you got the dispatch log? I've requested it. Have you got the camera? A pause. I've requested it. Then you don't have a suppression theory, Delilah said, without heat. You have a hypothesis. File the motion anyway. File it and set the hearing out as far as the court will let you. Quimby set down her pen. You want me to delay? I want the state to keep talking. It is worth saying plainly what happened in that room, because it is the hinge of the entire thing. A woman who could have ended her own prosecution with a single phone call chose instead to sit inside it and let the machine run, and let every officer involved commit, in writing and under oath, to a version of a night that had not happened, because a lie told once is a mistake. A lie repeated across a report, a supplement, a grand jury presentation, and a sworn hearing is something else entirely, and it has a statute number, and the number is not hers to enforce, and that mattered too. But she wasn't ready to explain that part to anyone yet. She said only, "Don't stop it. Let it develop." The pretrial hearing was set for a Tuesday in late June. The corridor outside Courtroom 2 in the Delphi County Courthouse is narrow, and it was crowded that morning with a docket of 41 cases, and Delilah stood against the wall, with her folder squared under her arm, while Quimby went in to check the call order. Fletcher Rand came down that corridor with a coffee in one hand, and he was moving faster than the space allowed, and he had seen her from 30 feet away. The shoulder caught her high on the left arm and turned her hard into the wall. The folder went, 206 pages of a woman's life went across a courthouse floor, probate filings, receipts, a hand-drawn timeline, the parts store bulb slip with the initials in the corner. "Watch yourself," Rand said, and kept walking, and did not look back, and the coffee did not spill, which is the detail that told her everything, because a man who is genuinely off balance spills his coffee. She did not fall. She got a hand on the wall and took the impact through her shoulder and stayed on her feet, and she felt the flare of it go up into her neck, and for one clean second, her body offered her every option it had ever been trained to offer. She took none of them. She stood still for 3 full breaths. Then she crouched, and she picked up 206 pages, and she put them back in order, not roughly, in order, by date, the way she had built them, and it took her 4 minutes, and 11 people walked past her while she did it, and one of them, an older woman waiting on a child support docket, crouched down and helped her without saying anything at all, and Delilah said thank you, and meant it more than she could show. Then she stood up and squared the folder, and went into courtroom 2. Officer Blake Whitaker testified that morning on the state's motion practice. He was sworn. He put his hand up and swore, and then he said the following, and a stenographer took it down, that the stop was initiated at approximately 9:04 p.m. for an equipment violation, that the operator appeared, in his words, unusually rehearsed, that the canine unit was requested at the outset of the encounter, that the canine arrived within approximately 10 minutes, that his body-worn camera was activated for the duration of the stop and had been uploaded to the department server in accordance with policy. Delilah sat in the second row with her folder on her knees and her hands folded on top of it and did not move. 10 minutes. He had said 10 minutes. Caleb had read the time off his phone at 9:16, and the dog had not been on that road yet, and the third unit had rolled in at 9:33, and she had counted every one of those minutes twice, once as they happened, and once on a concrete bench under a light that did not go off. Within approximately 10 minutes, she felt it settle into her chest, cold and clean, the way a number settles when you know it is going to be load-bearing. He had also said the camera ran the whole time. He had said that under oath, on a Tuesday in June, in front of a judge, a prosecutor, a clerk, and a stenographer, and it was now, permanently, a thing that existed. Hazel Quimby's cross-examination lasted 11 minutes and got nowhere, because she did not yet have a single document to hold in her hand, and she sat down knowing it, and her ears were red. Outside afterward, on the courthouse steps, she said, "That's the whole hearing. He's consistent. He's polished. He's done this before." "I know. You're not, Miss Ashcroft, I have to ask, you're not reacting to any of this." "I'm reacting," Delilah said. "You're just not seeing where." That evening she sat in Martha's kitchen with the porch light buzzing behind the screen door and typed a message to a number she had not used in 11 weeks. Cassian Boone. 6 words, no punctuation to speak of, sent at 9:41 p.m. Do nothing. Let him keep talking. The reply took 4 minutes. "Ma'am, understood. But you know what he said today goes in a transcript." She looked at that for a long moment. Then she typed, "That's the point." She set the phone face down on the table, next to a legal pad with 4 lines on it, and 3 of them still marked NYT, and she looked out at a dark county road where a bulb had been out that was not out, and she thought about a young man asleep upstairs with an administrative hold on the only door he'd ever gotten open. If you're still here, like the video, and tell me in the comments, would you have shown the card that night, or would you have waited? Because here is what nobody in Delphi County knew yet, in that late June, with a trial date pending, and a woman on the docket in a gray cardigan who had never once raised her voice. The plate bulb had been replaced 11 days before the stop, and she had the receipt. The dog arrived 26 minutes into a stop for a bulb, and she had the minute. And in the pocket of that gray cardigan, on a county highway at 9:04 p.m. on a Thursday in April, something had been switched on before the flashlight ever reached the window. Legally, under a statute that exists in the state of Ohio, and that Officer Blake Whitaker had apparently never once had reason to read. It had run for 34 minutes, and it had not stopped when the door locked twice. The documents came the way documents always come, which is late, incomplete, and in the wrong order. Hazel Quimby's discovery packet arrived in the second week of July, 109 pages, and Delilah read all of it at the kitchen table across 2 nights with a legal pad at her elbow and a pen she did not put down. She read it the way a person reads a contract they intend to enforce. Slowly, twice, once forward for content and once backward for absence, because absence is where the truth usually keeps its coat. The dispatch log came first, and it was 4 columns wide and unglamorous, and it was the most beautiful thing she had seen in 3 months. She read it aloud to the empty room, the way she had learned to do when a fact needed to become permanent. Unit 412, traffic stop initiated, County Route 9 at mile marker 7, 2100 4 hours. Unit 408 requested for assist, 2122. Unit 408 on scene, 2129. Canine unit requested through county, 2124. Canine on scene, 2133. 9:04 to 9:33, 29 minutes. And the request for the dog had not gone out at the beginning of the encounter, as Whitaker had sworn on a Tuesday in June. It had gone out at 9:22, 18 minutes into a stop for a bulb, after the man had already walked back to his cruiser with her license and had already had every piece of information he would ever need to write her a citation and let her go. She underlined the 2 timestamps and wrote the transcript page number beside them and drew a single short line between the two, and that line was the entire case. The body-worn camera footage came on a disc in a paper sleeve, and it was where the second thing lived. There were 2 files. The first ran from 2104 to 2109, 5 minutes and 11 seconds, and it was the window, the license, the plate light, and it ended with the officer walking back toward the cruiser. The second file began at 2120 and ran to the end of the encounter. 11 minutes were not there. Not corrupted, not black, not corrupted, not black, not present at all, a gap between 2 files, with a metadata block that said the device had been placed in standby at 2109 and reactivated at 2120, and a department policy in the same packet, Section 4.2.1 of the Quarry Hollow Police Department Standard Operating Procedures, revised 2 years earlier, that read, "Recording shall continue uninterrupted from the initiation of any enforcement contact until the Quarry Hollow Police Department Standard Operating Procedures," revised 2 years earlier. Deactivation during an active contact requires a verbal statement of reason on the recording. There was no verbal statement of reason on the recording. There was simply a man, and then 11 minutes of nothing, and then a man again. The evidence submission sheet was the third thing, and it was a single page, and it had 2 signature lines. Submitting officer, B. Whitaker, badge 217. Receiving officer, O. Pruitt, badge 104. Date of submission listed as the following morning at 8:15 a.m., 11 hours after the stop. Nowhere in 109 pages was there a document accounting for where that twist of plastic had been between 9:38 at night and 8:15 the next morning. No secure locker log, no temporary storage entry, nothing. In a properly run agency, a chain of custody is a chain, every link named, every transfer timed and initialed, and what Delilah was holding was not a chain. It was 2 hooks with air between them. She wrote the words NYT beside one line only now, the lab report, and drew a box around it. If you have ever been told to just be patient and let the system work, stay with me. Hit that like button and let's see how the system actually works. The lab report arrived 19 days later, and it was 1 paragraph long, and it said the submitted material weighed 1.1 grams and tested positive for a compound consistent with a cutting agent commonly encountered in adulterated street samples, with no controlled substance identified above the reporting threshold. Delilah read that sentence 4 times. It did not say the powder was harmless. It did not say anyone had made a mistake. What it said, in the anesthetized dialect that laboratories use to avoid taking sides, was that the state of Ohio had indicted a woman for possessing something that was not, in fact, a controlled substance. Hazel Quimby called at 7:40 a.m. the morning she got her copy, and her voice was doing something it had not done before. "They're going to have to deal with this. I'm filing an amended motion today. Ms. Ashcroft, this changes. Don't file it today. I'm sorry? File it with the suppression motion. 1 filing. Set the hearing for the earliest date after the state's response deadline runs, and do not call the prosecutor to discuss it beforehand. There was a silence on the line long enough to hear an office phone ringing behind her. You've done this before, Quimby said. I've watched it done. That's not what I asked. I know, Delilah said. File it together. Willow Brandt got there on her own, which Delilah always maintained afterward was the important part. Brandt was a reporter for a 5-person newsroom out of Delphi that covered 4 counties and had not had a subscription increase in 6 years, and she had been keeping a spreadsheet for 11 months of every case in Delphi County that began with a nighttime stop on County Route 9. She had 31 entries. 22 of them involved a canine request. 19 of the 22 involved a driver whom the arresting narrative described using one of 4 adjectives, and Brandt had highlighted the adjectives in yellow, and when she showed the spreadsheet to Delilah across a diner table, she did it apologetically, as though the pattern were something she had done, rather than something she had found. I filed a public records request in April, Brandt said, for the corridor enforcement assignments. Everything the department produced was redacted. She slid a photocopy across the table. Delilah read it aloud in a flat voice, the way she read everything. Subject line, corridor detail, Route 9, spring rotation, sent from a department address, to, redacted, copied to, redacted, body, 2 full paragraphs blacked out. The exemption cited in the margin was a general law enforcement investigatory records provision, applied to an email that had been sent 9 months before any investigation existed. At the bottom, below the black bars, one line had survived. Numbers are soft this quarter. Let's fix that before the council meeting. Neither woman said anything for a moment. I asked the chief about it, Brandt said. Stapleton. He said it was a scheduling email. It might be. You believe that? I believe it's a scheduling email, Delilah said. I just want to know what was being scheduled. Otis Pruitt fulfilled her public records request on day 94, and he fulfilled it precisely, and every page he handed through the glass was a page she already had, and he knew it, and she knew he knew it, and he timed the stamp on the release form with visible satisfaction. That completes your request, he said. It does. You'll note we were thorough. I've noted it, Delilah said, and photographed the release form at the window, and Pruitt watched her do it, and this time he said something. You know what I think about you, Miss Ashcroft? And tell me. I think you've read a lot of pamphlets. He squared a stack of forms that did not need squaring. There's people who come through here who think knowing the words is the same as having the words mean something. It isn't. Words mean something when the system says they do. And out here, I'm a fair piece of the system. She looked at him for that extra second she always took. Sergeant, she said, I want to be sure I have this right, so I'm going to repeat it back. You're telling me that the accuracy of a record depends on who's holding it. His jaw moved. That's not what I said. It's what I heard, she said. 3:11 p.m. Thank you for your time. That was the 4th week of September, and it was also the week that Cassian Boone called her from a parking garage in another state and got as close as he ever got to losing his composure. Ma'am, I'm going to say this once, and then I'm going to shut up and do what you tell me. There is a transcript in a county courthouse in Ohio in which a sworn officer describes a version of events that a dispatch log contradicts on its face. That is not going away. It is sitting there. If this comes out sideways, if a reporter finds it before we route it, every single person on the 6th floor is going to be asked why you sat on it for 5 months. Because 5 months is how long it took him to say it 4 times. I understand the theory. It isn't a theory, Mr. Boone. It's a rule of evidence. One inconsistent statement is a bad memory. A report, a supplement, a grand jury presentation, and sworn testimony that all move in the same direction, away from a document he didn't know I'd get. That's a pattern, and a pattern is the only thing anybody ever gets held to. A pause. The sound of a car door somewhere. "Ms. Ashcroft," he said, and there was something almost formal in it, something careful. "For what it's worth, nobody in the building thinks you should have had to do this alone." "Thank you, Mr. Boone." "Yes, ma'am." She sat with the phone in her hand for a while after that, because the way he said it, Ms. Ashcroft in that voice, from a man who had 400 people under him, was the closest thing to comfort she had been offered since April, and she had not realized until it arrived how much she had needed something. Then she put the phone down and went back to her legal pad. The suppression hearing was held on the 14th of October, 5 months and 21 days after a plate light that worked stopped a car on a county road. Courtroom 2 was fuller than usual. Willow Brandt sat in the back row with a notebook. Caleb sat in the 3rd row in a shirt with a collar, 17 and a half now, holding his own hands. Heather Lindgren was there, which surprised exactly no one, in the 2nd row on the aisle, in the posture of a woman attending something on behalf of a community. The state called Officer Blake Whitaker. He was sworn. He was polished. He said, again, that the canine had been requested at the outset of the encounter and had arrived within approximately 10 minutes, and that his body-worn camera had recorded the contact in accordance with policy, and Delilah watched him say it and felt nothing at all, which she noted, distantly, as a thing to think about later. Hazel Quimby stood up. She was still 31, and still carrying 142 files, but she had spent 9 days on one of them, and it showed in the way she laid 3 documents on the podium and did not touch them. "Officer, I'm going to hand you what's been marked Defense Exhibit A. Do you recognize it? It appears to be a dispatch log. Read the entry timed 2122. He read it. Read the entry timed 2124. He read it. That's a canine request, is that right? That's what it reflects. 18 minutes after the stop was initiated. A pause. That's what the log reflects. Objection. The prosecutor, half rising. Argumentative. Overruled. Quimby moved to Exhibit B, the 2 video files and the metadata block, and asked him to state, from the record, the time his camera entered standby and the time it resumed, and he read those too, in a voice that had gone flat and careful, and then she asked whether department policy required a verbal statement of reason for deactivation during an active contact, and he said it did, and she asked whether one appeared on the recording, and he said after 4 seconds that he did not recall making one. Then she picked up Exhibit C, which was the lab report, and she did not hand it to him at all. "Officer, are you aware that the substance you recovered contained no controlled substance above the reporting threshold?" Objection, foundation. Sustained. "I'll move on," Quimby said, and sat down, and did not look at anyone, and Delilah thought, "Good. That's exactly right. Don't take the win in front of them." Judge Hollingsworth suppressed the evidence from the bench in 4 minutes, citing Rodriguez versus United States, and finding that the purpose of the traffic stop had been complete before the canine was requested, and that no independent reasonable suspicion supported the extension. She noted for the record her concern regarding the 11-minute gap and the absence of any temporary storage entry, and she said the words chain of custody twice in one sentence, which is a thing judges do when they are building an appellate record in advance. The prosecutor asked for a recess. He came back 35 minutes later and moved to dismiss, and the motion was granted, and the entry read, nolle prosequi, the state declining to proceed, which is not the same as an acquittal, and never will be, and which meant that for the rest of Delilah Ashcroft's life, a background search would show an arrest and an indictment and a dismissal, and would not show why. That was the moment she stood up. Your Honor, before the court adjourns, I'd like to be heard on a related matter, and I'd like the record to remain open. Hollingsworth looked at her over the glasses. Miss Ashcroft, you're represented. Quimby, half standing, half lost. Your Honor, Yes, she may be heard. Delilah came forward with the folder she had carried through a courthouse corridor on a June morning and picked up off the floor, page by page. My name is Delilah Ashcroft. I've given this court my name 4 times since April, and I've never given it my title, because my title was not relevant to whether a bulb was lit on County Route 9. It's relevant now. She opened a leather case and set it flat on the podium where the clerk could see it and the stenographer could hear her describe it. Federal Identification, United States Department of Justice, Federal Bureau of Investigation. I am the Assistant Director of the Inspection Division. My division audits the Bureau's own field offices for procedural compliance. I investigate the people I work with. I do it full-time. The room did the thing rooms do. Heather Lindgren's hand came up to her collarbone and stayed. Willow Brandt stopped writing entirely, which is the only real compliment a reporter can pay. In the third row, a 17-year-old boy put both hands over his mouth and did not move. Whitaker, still at counsel table, had gone a color that does not have a name. I want to be extremely clear with this court about what that title does not mean, Delilah said. It gives me no authority whatsoever over the Quarry Hollow Police Department. None. I have no jurisdiction here. I cannot investigate this case. I cannot direct anyone who can, and if I tried, I would be the misconduct. In this courtroom I am one thing only, and that is a witness. She turned one page. On April 18th, at approximately 9:03 p.m., before this stop was initiated, I activated an audio recording application on my personal telephone. I did that because it was dark, because there were no fixed cameras on that stretch of road, and because I had a 17-year-old in the passenger seat. Ohio Revised Code Section 2933.52, subsection B, paragraph 4, permits any person who is a party to a communication to record that communication. I was a party. It is lawful. It has been lawful in this state for a very long time. She let one beat go by. In a room that quiet, one beat is a long time. It ran for 34 minutes and 11 seconds. It did not stop when the door was closed. The prosecutor was on his feet. Your Honor, I'm not offering it here, Delilah said. This court has already dismissed. This court is the wrong forum, and this county is the wrong county, because a police department cannot meaningfully investigate itself, and a prosecutor who tries these officers' cases every week cannot meaningfully prosecute them. So I'm going to tell the court what I have already done." She read the next line off the page, because she had written it down in advance, and she wanted the words to be exactly the words. On June 18th, the day after Officer Whitaker's first sworn testimony in this matter, I delivered the recording, the timeline, and the underlying documents to the Civil Rights Division of the United States Department of Justice through the Special Litigation Section and to the Cincinnati Field Office of the FBI. I have had no involvement in that matter since the day I handed it over. I have not called anyone. I have not asked anyone anything. I am a complaining witness in a federal matter and nothing else, and I have kept it that way on purpose. And every one of those handoffs is documented, timed, and initialed. She closed the folder. "That's why I let him talk," she said. "Not to trap a man, to let a record build itself somewhere I couldn't be accused of building it. If that hit you the way it hit me writing it, subscribe. There's one more turn in this, and it's the part people usually get wrong. What happened next took 26 months, and almost none of it was satisfying, and all of it was real. Blake Whitaker was placed on paid administrative leave the following morning. Not fired, paid. The collective bargaining agreement between the village and the Fraternal Order of Police required a pre-disciplinary conference, written notice of charges, and a union representative, and it took 11 weeks to schedule all three, during which Officer Whitaker collected a salary of $61,400 annualized and taught his son's youth baseball team. Chief Raymond Stapleton issued a 2-paragraph statement calling the matter an isolated personnel issue and reminding the public that his officers work a dangerous corridor. He gave one interview to a television station out of Columbus, in which he said the phrase, "We take these allegations seriously" twice, and the phrase "pending review" 5 times. He did not resign. He retired 18 months later with a full pension at 58, and the village council voted 6-1 to thank him for his service. And Heather Lindgren, who by then had stopped returning calls from reporters, voted with the 6. The federal case took 11 months to become an indictment. The United States Attorney for the Southern District of Ohio charged Blake Whitaker with 1 count under Title 18, United States Code, Section 242, deprivation of rights under color of law, and 1 count under Section 1519, falsification of records in a federal matter. Both are real statutes and neither is easy, because Section 242 requires the government to prove that the defendant acted willfully, which is one of the highest mental state standards in federal criminal law, and juries do not hand it out casually. He pled to the falsification count in the 14th month. The deprivation count was dismissed as part of the agreement. The guidelines range came in low because he had no criminal history, and the judge sentenced him to 18 months, and he served 14 at a federal facility in Kentucky, and he was released on a Tuesday in the spring, and nobody photographed it. Fletcher Rand was never charged with anything. An internal investigation found that he had deactivated a camera in violation of policy on 9 separate occasions across 2 years, and he received a written reprimand and 40 hours of unpaid suspension, and 8 months later he was hired by a department 2 counties over that had not asked, and he is a police officer today. Otis Pruitt was found in an audit of the Quarry Hollow evidence room commissioned by the village at a cost of $41,000 to have maintained a chain of custody system with, in the auditor's words, substantial and recurring documentation deficiencies affecting an estimated 14% of submissions over a 5-year period. He was not accused of theft. He was not accused of tampering. He was permitted to retire in place, with his benefits intact, and at his going-away gathering, there was a sheet cake, and someone made a joke about paperwork, and everyone laughed. The civil case under Title 42, United States Code, Section 1983, took another 14 months and never saw a jury. The village's insurer settled for $290,000. The agreement contained the standard language: no admission of liability, no admission of wrongdoing by any party, and a mutual non-disparagement clause that Delilah's attorney negotiated down until it applied to the parties and not to the facts, which she said afterward was the only part of the entire document she was proud of. The insurer paid. The village's premium went up 11%. No individual officer paid $1, and in the 22nd month, the Civil Rights Division opened a pattern or practice review of the Quarry Hollow Police Department and the Delphi County Sheriff's Office under Title 34, United States Code, Section 12601. Salome Ruiz, the attorney who signed the opening letter, gave one public statement, and it was 11 words long. The review is preliminary, it is not a finding, and it is ongoing. 41 cases in which Blake Whitaker had been the sole or primary affiant were flagged for review by the Delphi County Prosecutor's Office. 9 convictions were vacated. 2 of those 9 involved people who had already finished their sentences. One involved a man named Bradley, who had lost a commercial driver's license and a marriage, and did not get either of them back when the entry was corrected. The remaining 32 cases were, in the language of the county's own quarterly report, under continuing evaluation. They are still under continuing evaluation. Caleb Ashcroft's scholarship hold was lifted in November, 5 weeks after the dismissal, in an email that ran 2 sentences and did not apologize for anything. He started a semester late. He is in his 2nd year now at a state engineering program, and he works Saturdays at a tooling plant outside Dayton, and he has a habit his aunt gave him and does not fully understand yet, which is that he writes the time in the margin of things. Heather Lindgren sent a letter in the 3rd week of December, 4 pages, handwritten. It arrived on a Thursday. Delilah put it on the shelf above the kitchen radiator, unopened, and it is still there, and she has not decided anything about it, and she has stopped feeling that she owes anyone a decision. Willow Brandt's 4-part series ran the following spring and won a regional award, and in her acceptance remarks she said the thing that stuck, which was that the story had not been broken by a reporter or a federal official, but by a dispatch log that had existed in a filing system the entire time and that nobody had asked for. The village council voted, in the 24th month, to adopt a policy requiring continuous body-worn camera activation during all enforcement contacts, with automatic upload and a 90-day retention floor. The vote was 5-2. Implementation was made contingent on budget approval in the following fiscal year. The following fiscal year, the line item was deferred. 2 things were never explained. The 11 minutes are the first. In 14 months of federal process, across a plea agreement, a sentencing memorandum, and an internal audit, no document ever accounted for what occurred on County Route 9 between 9:09 and 9:20 p.m. on the 18th of April. Whitaker's plea did not require him to say. Nobody made him say. The gap sits in the file with a timestamp on either side of it, and it will sit there permanently, and Delilah has a copy of the metadata block in a folder in a house that she now owns outright, and she takes it out perhaps twice a year and looks at it and puts it away. The email is the second. Numbers are soft this quarter. Let's fix that before the council meeting. Sent 9 months before any of it began. The recipient field was redacted in the original production and remained redacted through 3 subsequent requests, and when Willow Brandt filed a mandamus action, the village released a further version in which the redaction had been reduced but not removed, and what was visible was 2 initials in the copy line. R.S. Raymond Stapleton retired at 58, with a full pension and a sheet cake of his own, and has never been interviewed under oath about anything, and answers his phone. On a Tuesday last April, at 4 in the morning, Delilah Ashcroft's phone lit up on the nightstand in a dark house on a county road. Delphi County area code, 11 seconds, no message. She did not call back. She wrote the time in the margin of the notepad she keeps beside the bed, and dated it, and initialed it, and lay there in the dark, listening to a road with almost nothing on it. And then she got up at 5 and made coffee, because the paper forgets, and she does not.